Hello, and welcome to the webinar on an exploration of the L-1 visa processes. I am your host for this webinar. My name is Dan Rock. I'm an attorney here at McEntee Law Group. And why don't we get started? First, we'll start with a disclaimer. This is a presentation for general information purposes and is not legal advice. Contact an attorney for individual advice. I am a lawyer, but I'm not necessarily your lawyer. So again, this is general information and not legal advice for your specific cases. Also, I do reference a couple of timelines in this video. These are current estimates. Timelines with USCIS processing can and do change on a fairly regular basis. So that is all dependent on the government workload. So we're going to cover kind of a lot of ground today. We're going to go over the basics of the L-1 visa, the L-1A, the L-1B, new office L-1. We'll touch briefly on the pathways to getting a green card for an L-1 holder. We'll talk about blanket L petitions, max out issues, and then time permitting, we'll go through a question and answer period at the end. So let's move along. So we'll start with just some very basic definitions. The petitioner is the U.S. company that sponsors the L-1 visa. The beneficiary will be the foreign national that the petitioner is seeking to bring to the U.S. And then that's a beneficiary. And then I want to highlight that the L-1 visa is a dual intent visa. That means that a person on L-1 has the ability to pursue legal permanent residency, the green card, while still in non-immigrant status within the U.S. So that's it. So what is L-1? L-1 is a visa that allows for transfers from among multinational companies. So transferring an employee from a foreign entity to a related U.S. entity. There are some requirements for that. Most notably, the person must have been with the company, sorry about that, for one of the preceding 3 years. So there has to be the relationship between the foreign entity and the employee before they're transferred to the U.S. The U.S. company must be a current operating business, it must be legally formed. So it has to be a company within the U.S. It has to be financially viable. So a company that's kind of on the brink of bankruptcy and doesn't really have prospects of being a successful company in the U.S. Probably is not going to cut it. And then there's got to be the business presence. So they have to be doing business in the U.S. and there's got to be a qualifying relationship between the foreign company and the U.S. company. Now, what is a qualifying relationship? What you're looking for is control among the foreign company and the U.S. company. So a parent U.S. company would be one that owns the foreign company and has control over it. Subsidiary would be where the foreign company owns a U.S. company. It could be a branch where it's not a separate corporate entity. It's just an office in the U.S. Of the foreign company. It could be an affiliate that would be a related company. Think of an accounting firm where they share the same name, they have a business relationship. A amongst partnership. And then with joint ventures, in specific situations, it could be a subsidiary to both if each company has 50% ownership and they share equally, kind of like down the middle, then a joint venture could be a subsidiary to two different foreign entities. Again, you're looking for some form of ownership and control among the entities. It can get a little bit more complicated, but that's kind of the overview. That, as I mentioned before, the intercompany transferee, that's the employee, must work at least 1 year of 3 year prior to admittance to the U.S. for the qualifying foreign entity. That would exclude periods of time for if they're traveling in the U.S. So if a person comes on the U.S. and B status to service contracts, which is perfectly acceptable, that time won't count towards that 1 year. So if they come for a total of 2 months and they started with a foreign entity a year ago, you would have to wait those additional 2 months for that 1 year of qualifying employment. Conversely, if they're in the U.S. In H-1B status, that's not going to count against the 3 year. That 3 year period is told while they're in the U.S. in the work authorized status, working for the U.S. company. So again, that wouldn't foreclose the L-1 if the person has been on H-1B status for the last 3 years with the U.S. company. They must have worked in a managerial, executive, or specialized knowledge role for the foreign entity, and we'll cover those in a little more detail when we talk about the L-1A and L-1B statuses in more depth. And they must be coming to the U.S. in a managerial or specialized knowledge or executive role. There are no prevailing wage requirements with L-1, unlike the H-1B. So there can be situations where in individual situations where an employee is paid below what would be a prevailing wage for H-1B purposes. However, USCIS will look to what the worker is making. So it would be difficult to argue that a person is managerial if they're making $20,000 a year, or that how special and necessary is a person to bring to the U.S. if they're making a really low wage. So although there is no prevailing wage requirement, it is something to be cognizant as you go through the process. And then you are looking for control over the employee. You can work offsite, but in fairly limited circumstances, and you're looking for the U.S. company to have control over the employee in that situation. Moving on, we're going to discuss the L-1A. The L-1A is a category for transferees coming to the U.S. to work in a managerial or executive role. The maximum period of stay in L-1 is 7 years. The petitions are generally granted for 3 years initially, and then from there on out, it's in 2 year increments. So it would typically be 3 years, 2 years, and 2 years. But if the person travels, we'll touch base on it a little bit later, but it could be more than 2 subsequent extensions if you recapture time or something of that nature. What are executive and managerial capacity? An executive directs the management of the organization, establishes goals and policies. They have wide latitude over decision-making and only receive general supervision from higher level executives. I'd note that for the executive, They must meet all four of these criteria to be considered an executive within the company. Moving on to a managerial capacity, I won't read this verbatim, but they manage organization, department, component of the organization or a function of the organization, supervise and control the work of other employees or manages an essential function. So there is a difference between a people manager and a functional manager. We'll touch base on in a little bit. Generally has the authority to hire, fire, recommend these sorts of actions, control over personnel generally, and exercises discretion over day-to-day operations of the activity or function that they manage. So generally speaking, manager is not a first line supervisor. They're managing managerial employees or degree professionals. They do have personnel decisions. So you look for hiring, firing, employee evaluations, approval of vacation and travel, just the things that show that they have control over the employees they manage. And want to see that they oversee day-to-day operations rather than perform the duties themselves. You're looking more for overseeing the activity rather than performing the duty. They can perform duties related to it, but you're looking for the degree to which they're performing versus overseeing, and you want the amount of time that they're overseeing other employees to be more than 50% of their time. The more the better, generally speaking. Now, a functional manager, they manage an essential function of the company. They don't need to directly supervise professional employees. They can oversee contractors and vendors. And you want to look at the hierarchy of the company. Are they on the same level as the managerial employees? So if you think of a company that has IT director but no direct employees underneath him, he might set policies and have a budget that they're in control of. The person might oversee a vendor that handles tech issues within the company, but not have direct reports within the company structure. That might be a situation where you would look to the functional manager. Now, if the IT director or IT manager position is kind of on the lower level of the hierarchy, then it might not qualify. You really have to look at the organizational structure and whether it makes sense that the person would be considered managerial in any given situation. So that's going to be very company by company specific as to whether or not a person in a functional manager role would be considered a manager. So that is kind of a brief overview of the L1A. We're moving on to the L1B. I'm just going to take one moment to take a quick look. Sorry. Okay. Oh, I went to slide further than I meant. Okay, so L1B, unlike the L1A, which is 7 years of a total period of stay, L1B is eligible for up to 5 years of stay in L1B status. That is typically a 3-year period followed by a single 2-year period. So it's not quite as long as with L1A. Specialized knowledge, this is, I believe, the only quote that I have, but it's foreign national has specialized knowledge if They have special knowledge of the company's products and its applications in international markets, or has an advanced level of knowledge of processes and procedures of the company. Let's move on to the next slide. We could explain that a little bit more clearly. The specialized knowledge doesn't necessarily have to be proprietary information about the company, but it has to be uncommon, can be advanced level knowledge of the company's policies or procedures. The advanced knowledge doesn't need to be narrowly held within the company. When you're preparing this sort of petition, you generally look to how long it would take to train a U.S. employee. Excuse me, I jumped ahead again. With the specialized knowledge, you look at knowledge of the company's manufacturing devices, products, that's distinct and uncommon from others within the industry. So with the specialized knowledge, like being from Chicago, while I was doing this, I was thinking of what would be a good example. And I thought of hot dogs. So Chicago is famous for it is home to Oscar Mayer, I believe, and Vienna beef. Not many people know how to make a hot dog, but just being able to have a general idea of how to make a hot dog and the processes that go into it wouldn't be enough to prove specialized knowledge. Now I know Vienna beef, they have special rules for the temperature the ingredients are when they're mixing them, how long they sit, how long they rest. So you're looking for someone that's going to know how a particular company does the manufactures their product or produces their product. And then advanced knowledge, you're looking the advanced knowledge is how the knowledge is used by the company. So you're more looking inward, whereas with the specialized knowledge, you're looking outward for everyone. With the advanced knowledge, you're looking inward, how the people within the company use the knowledge. So if they know the policies and procedures for the company in a way that's unusual or uncommon, that might lead you to think they have advanced knowledge. If it's something that would take a kind of a long time to obtain, that's the sort of thing that you would look for advanced knowledge in that regard. Now, sometimes companies don't have the business history that is typically necessary for the L-1 if they're just coming to the U.S. For an entity that has been in business for less than a year, you could file for a new office L. You need to show that the entity is in existence. You do need to meet that, and the foreign national will need to have been employed and meet the employment requirements with the foreign entity, but the U.S. operation is not going to have the same ability to show that they are viable in doing business and support the L-1. So what USCIS will do is grant an L-1 for a 1-year period with showing that you have the premises and that you kind of have the plan for developing the business to a point where within a year the person will be in a position to manage or be an executive for the U.S. entity. And then you have to file again after a year and show that you're meeting kind of the benchmarks that you said that you would for setting up when you were setting up the company that the company is doing business and really has a need for the managerial employee. The filing procedure, it is filed with a form I-129 with an L supplement. These are typically filed at a USCIS service center that would have jurisdiction over the primary place of employment. So if there's multiple offices in the US, you look to the primary place of employment on where they are filed. Canadians have the ability to file at special ports of entry that are set up to review these types of cases. The filing fee for the I-129 is $460. The first time filing, there is a fraud fee of $500 that's theoretically designed so that USCIS could investigate potential instances of fraud. That fee could be higher if the employer is a dependent employer, if they have more than 50% of their workforce in H-1B or an L-1 status, and they have more than 50 employees, then the fraud fee would be $4,500. So a significant jump, and that would be due each filing of the petition, not just the initial petition for the foreign national. And that there is the possibility of premium processing with the L-1, and that is a $2,500 fee. With premium processing, they agree to process the case, so issue a decision or a request for evidence within 15 days. And if they issue a request for evidence, they would issue a decision within 15 days from the time they receive the response. Without premium processing, current processing times are 1.5 months to 2 months. So they're actually pretty good relative to most of USCIS's processing times. Although USCIS is supposed to process these cases in 30 days or less, so they're not meeting the requirements that are imposed on them to process them within 30 days. But relatively speaking, they are pretty good processing times at the moment. Moving on, the L-1, as I mentioned earlier, is a dual intent status. So a foreign national in L-1 status can at the same time pursue a green card. With L-1A, there is usually the ability to apply for an EB-1C multinational manager I-140 immigrant petition. That is for managerial employees moving from a managerial position abroad to a managerial position in the US. Typically speaking, L-1As will qualify for that. In general, USCIS is a little more restrictive in their review of immigrant petitions than non-immigrant cases. So if you have an L-1 that is a little bit on the margins, or if you have someone that qualified for the L-1 based on specialized knowledge abroad, but came to the US to perform a managerial function, then you might run into trouble. With the L-1B, there is no direct filing of the I-140 based on the employment. So you're looking for another method of seeking the immigrant petition, which typically would be through a labor certification process where you test the US labor market. Generally speaking, when you're doing the labor certification, you have to show that there are no willing and able U.S. workers that can take the position. With current backlogs, it's important to start the process early for your L-1B employees. One thing to notice, typically you can't show that the person qualifies for the U.S. position with same or similar work for the U.S. company for the labor certification. With the L-1B, you can use their foreign employment, but you wouldn't be able to use their U.S. employment to show that they qualify for the U.S. position. So any positions that you set or any requirements that you set for the labor certification should be reflective that they met the position requirements before coming to the U.S. And then companies that have kind of a need for a number of L-1 employees can file for a blanket petition. A blanket petition gives a company a chance to pre-certify that the qualifying relationship, and then the employee could actually file their petition and with the consular office that issues the visa rather than through USCIS. A blanket petition, you would submit all the documentation to show your qualifying relationships for all your companies or all the companies that you want on your blanket petition. And there are occasions where just a company that might be difficult to show the relationship, and you don't expect to bring L-1 employees over, you might leave them off your blanket petition, but you can pre-qualify your corporate relationships. So you don't need to prove that on each individual petition. When you file for a blanket petition, it is typically for 3 years. And then you could renew it for an indefinite period of time. And then once you have the indefinite blanket petition, you don't really need to renew it on any set schedule. But if you have kind of a corporate restructuring or a merger or something like that, you would likely want to amend your blanket petition and show the new entities, the new corporate relationships, if there has been a change in your employee. There are certain requirements for a company to file a blanket petition. The petitioner must have been doing business in the U.S. for 1 year. The petitioner must have 3 or more domestic and foreign qualifying organizations. So you could have a parent with 2 subsidiaries, or you could have an organization that has some affiliates overseas. It just can't be a one-on-one relationship. And then you have to have kind of the volume, the size that warrants it. The USCIS will accept a showing of U.S. sales of $25 million, a workforce of 1,000 employees, or 10 L1 petitions within the prior 12 months. So that kind of shows the necessity to be able to use this streamlined process that is quite helpful. Let's go on to the next slide. And then the final things I wanted to talk about, or topic I wanted to cover under this, is max out dates issues. As I said previously, there is a maximum period of stay of 7 years with an L1A and 5 years with an L1B. There are some ways around it. The intermittent L is a good option if an employee is only coming over for brief periods of time. If it's less than 6 months every year, you could show that they're not going to be here more than 6 months a year, then you could file for an intermittent L, which would not be subject to the limitation. You can also seek to recapture time spent outside the U.S. The period of stay in L1 status only counts while the employee is in the U.S. So if the employee is transferred back to the qualifying foreign entity for a period of time, or even just short trips outside the US, if you need to recapture a short period of time, you could do that by recapturing time. And there you just would file a new petition that documents the time outside the US and request that period of stay. An L1B employee could move to L1A if the employee is in a managerial role in the US or advances to a managerial role within the US. So if you run into a situation where an employee kind of progresses through and takes on a bigger responsibility in the US, they could qualify for the L1A, you could get that additional 2-year period by seeking a change from the L1B to the L1A. And then a foreign national can reset that 7 or 5 year period by spending 1 year outside of the US. So if they work for the foreign entity for another year outside the US, you could reset that 5 and 7 year period. I also wanted to mention that when going back to the blanket L, there are special certain differences between the blanket petition and the filing with USCIS. With the blanket petition, L1Bs must be professionals, whereas that's not necessarily not a requirement for filing an L1B with USCIS. And if a company gets a blanket petition, they can file at either USCIS or the consulate, depending on their situation. So I also wanted to touch base on documents that you would include in the petition. When you file a petition, you'll want to include a copy of the beneficiary's passport, status documents if they're in the US. You'll want to document their terms of employment, either through a contract or a support letter that describes it. You'll need evidence of the qualifying employment abroad. So you'll need evidence of their specialized knowledge or their managerial work abroad. You'll typically need to include 1 year worth of pay stubs for the foreign national. Often include a letter from the foreign entity documenting their employment there with that entity, an organizational chart, evidence of their management, or chart with CVs and degree documents from their subordinates is a good way to show that they're managing degree professionals. You could also include emails where they're approving time off or making hiring, firing decision, evaluations of their employees, that sort of thing. For specialized knowledge, you could include training certificates. Again, the letter from the foreign entity that kind of highlights how they develop their specialized or advanced knowledge, and like process manuals, things of that nature that demonstrate the complexity of their knowledge with the foreign entity. You'll obviously need to document the corporate relationship. That could be done through incorporation documents, tax certificates, that sort of thing, company bylaws. especially with a new office L petition, you'll want to include a business plan that shows kind of the path forward, how you intend to turn the company into a viable business that needs to have an executive or a manager in the US. And then you'll need financial documents such as tax returns and bank statements to show that you have the ability to pay. I will open it up to any questions. Let's see, I do not see any there. It appears there are none. I'll give a moment for questions while I move on to I encourage you to follow McKinsey Law Group on social media through Instagram, Twitter, TikTok, Facebook, LinkedIn, and YouTube. All of the firm's contact information is provided there. Let me end this. And I believe that will conclude our presentation. Thank you for your attendance today. All right. That concludes it.